Subhanallah.
Your mic.
Indeed. Yes. Oh, my love.
Anytime.
My happiness.
I don't have time.
Love of my life.
You know I'm on proposals last minute.
Seriously?
Yes, now.
Babe, how many minutes for butter?
30 minutes. 30 minutes now. I want to scope into happy wash it. I'll think about it. I'm going to a lot, so I'll think about it. Okay, so I don't have time this evening now. Maybe tomorrow. I don't know. Fine, you can't send me now. No greet me.
Mute yourself.
If you don't die, or to dying.
Check my again in the class.
Yeah. Well, so you want to give me access to class? I'm not watching. What do you mean for? Me for? Send your mood. Let them.
Adewumi, they mute your mic.
Yeah. Let's not even spend that. Best okay now. What is doing this one?
Melon.
What do you need to say? Oh, yeah, I think that's because of shoot.
Leave me alone. Let me put my leg very good.
Okay, your leg, my legs are resting. Leg is resting somewhere already.
Alpha, mute yourself now. Carry yourself to WhatsApp and joke.
Like this woman don't dey talk.
So good evening, everyone. How are you today? Please do not forget the instructions that we make use of the chat box. You do not unmute until you are being told to. So if you can remember the last time we were on capacity, Please, which of the capacity did we end? Have we treated corporations under capacity? Have we treated it? Okay, so did we end at corporation or we have gone further than this? Have we gone further than corporation? Okay, so remember that when we started capacity last week, the general principle when it comes to capacity. All right, so if you can remember that the general principle, what the general principle says is that everybody has capacity to contract. That is the general principle, that everybody can, more or less we can say everybody can be engaged in a contract. But because some people, there's possibility that some people may be cheated, so the court or the law tries to protect this set of people, that there's probability that they can be exploited. And amongst them, these people, they are children, we call them infants, persons of unsound mind, drunken persons, corporations, and illiterate. And we have mentioned the fact that initially the age for children is 21 years and below, but subsequently it's been changed to 18 years and below. But that we still have some states in Nigeria, 2 states in Nigeria that are yet to do that. Can you mention the 2 states that are yet to have such provision in their child's rights, child's acts? I'm expecting to see better. I asked for the 2. Okay, so it's not Kaduna. Look at it very well. It is Kano and Zamfara. Kano and Zamfara, not Kaduna. So you don't make mistake. If there's any question regarding that, the exam or where there's anyone trying to clarify issues from you, you're expected to know all this, okay? So we mentioned the fact that when it comes to insane persons too and drunken persons, that the law also says they can be involved in a contract, but there are exceptions. The exceptions are that if they can say to the courts or to anyone that they were not aware of what the contract was, as in they were not themselves at that time they had entered into the contract, or that the person whom they had been involved in a contract with, that person actually knows their states, knows them, knows that they are mental, they are insane, and so that person had exploited them based on that. The same goes for drunken person. And we mentioned that for corporations, that it's not as if we are saying they cannot be involved. They also can be involved in a contract. But if you can remember the last time I mentioned objectives of a company, every company has an objective. You see, in life, there are a lot of times that we see creation at play. The way God had created us for some specific objective, for some specific reasons, so are companies also created. Thank God for company. In the case of the company, they are all highlighted and same are being submitted with the CAC. And the good thing about CAC is that all of these things that you have submitted with them, they also replicate same and give it back to them after they have signed it at their office. So every company has its objective in their possession. Another good thing about objective of a company is that everybody have access to it. when you go to CAC, you apply for it and you pay the requisite sum of money, it will be given to you because it is a public document. So you as when you finish from here, you start working, you finish from management sciences, and everything there has to do with commercial transaction, at least to some extent. Whenever you are dealing with companies, you just don't deal with them based on the document they had given to you. Although there are some laws that says, oh, that's sufficient. But because you are trying to protect your company, you can go further ahead. Apply to CAC to know the objectives of this company. Now, if you are able to know the objectives of the company, you will be able to make informed decision. You'll be able to do the right thing, because if any company is acting ultra-vires, that means they are acting outside of the scope of their objective. What it means is that whatever they have done is void. We cannot place something on nothing. It is void. And so you may not be able to get remedies from the court, except if you're able to defend your case properly. But look at the stress it takes you before you go to court and come back. So you want to do due diligence before you go ahead to sign contract with any company. And the next one that we have here is illiterate persons. Now, this set of people, they are very unique as well. In as much as they are okay, they are not children, they are not companies, but they have some form of deficit. Will I say they are not protected, and the way the law protects them is such that if you want to be involved in a contract with them, it behoves on you to ensure that you follow all the laid down principles. That was already. Okay. Hear me? I want to be sure you can hear me. Can you hear me? Okay, thank God. I was able to get it on time. All right, so I hope you can, the electricity in the school is down for now. All right, so like I was saying, so when it comes to illiterate person, the position of the law is that they can also be involved in a contract, but there are some laid down principle of law. And the laid down principle is that if you want to be involved in such a contract with that person, you, the writer, or whoever the writer is, need to read it out to them clearly. That is, ensure that they confirm that those instructions or anything that has been written in that contract is well comprehended by them, which means that they understood everything in the contract. And so, after they had done that, they would have to sign. Now, before I go further, we need to define who an illiterate is. You know, a lot of the times, if I ask you who an illiterate is without having shown you this, my slide, you would have told me that an illiterate person is a person that cannot read or write. That is the dictionary meaning. And I think at this time, so far so good, you would have noticed that when it comes to law, definition in law, they are not the same as definition in the ordinary balance. In the day-to-day activities of people, definition of law is extremely different because the law is not ambiguous. The law tries to make everything simple and clear. All right? The law tries to make it simple and clear. And so this is the position of the law. The law provides that the definition of an illiterate is anybody that cannot read or write or comprehend in the language of the contract. So the fact that my grandmom cannot read or write in English doesn't mean she cannot read or write in Yoruba. And if any contract is drafted in Yoruba language, she cannot come up and say, that means if she can read, and a lot of the time, some of our grandmas can, all right? It doesn't mean at that point she cannot claim she's an illiterate. Although the language of the law in Nigeria is English, I'm just assuming that let's assume there's a rule that Yoruba can also. So if the contract is drafted in Yoruba language, she cannot claim illiterate because she would be able to read and write in Yoruba. But in the case where it is drafted in English, that would have to be read out to her clearly. And she would tell whoever that reads or wrote it that she understood the language. Sorry, she understood the interpretation of what was in it. They have to read and interpret to her so she can comprehend it before you go ahead, all right? And so that is it for a lot of things. We have a lot of things here that because everything all starts from in the olden times. Before now, it used to be, even before typewriter, people use biro pen. I think it's an ink pen that they used in writing then. So, and we have a few people that can read or write at that time. Okay, so these few people, they're so few that they don't have a designated place. They move around the country or they move around the environment. They might be in Lagos State today and be in Abuja tomorrow. So the position of the law then, was that whoever that has written that needs to write, after they have read and the illiterate understood the content, the person who wrote it would have to sign the document as well and write down their address. And the purpose is such that if there is any dispute regarding the paper they had written or the letter or the content of the contract, they will be called upon as a witness. The address is so you know where to call them from, you know where to write a letter to and how to get them across. And the signature and name is so that you know them. Now, if all of the rules are not complied with, we have some things that follows. The consequences of non-compliance. One of it is if the document creates legal rights in favor of the writer cannot enforce the right. And so if the writer, eventually while they were writing it, he did it in such a way that he's going to profit from it. And at the end of the day, they noticed that it wasn't profitable or it wasn't in the interest of the illiterate person. The documents eventually may not be allowed to favor the writer, all right? If it is the illiterate person, if the illiterate person had gained from it before, and after they had profited from it, they are now coming again to come and say, oh, I'm an illiterate person, I do not understand, it wasn't read to me. Even if it wasn't read to them, the court will look at the fact that because there are some people, even if they are illiterate, the fact that they cannot write, some cannot write English properly, but they can understand it. So the court will try as much as possible to ensure that all parties goes home in fairness. That means the court will bring the law of equity into place. Now, you see me writing penalty of 100 naira, fine, or 6 months imprisonment. Now, we are still expecting that this law will be reviewed because we still have it. It's been a long time that we have this law, and that we are expecting that this to be reviewed subsequently, because 100 naira is not even a fine now. It's not even, you hardly see 100 naira nowadays, all right? So as not to take our time, let's quickly move to another thing, and that is privity of contracts. Privity, that is for capacity. We are done with capacity. Now we are moving to privity of contracts. So Okay. So, privity of contract. What is privity of contract? The essence of privity of contract is just to regulate contract law. And the general principle in privity of contract is that anyone that is not a party to a contract cannot benefit from that contract. So if a contract is between Tade and Tayo, Kehinde, Tade or Kehinde or Chukwudi or Aruna cannot enjoy any benefit from this. All right, that is it. But then there are some exceptions when it comes to privity of contract. And the exceptions are that there are some cases that it doesn't work like that. And so we are going to look at those exceptions now. Because if we say we want to enforce a strict principle of privity, it will bring or it will cause hardship on some set of people who are expected to benefit from it. Who are those that you think this rule of privity of contracts would work hardship on? Some people said next of kin, elderly. I'm still expecting more responses. Who are those that you think would not benefit? Some people say spouses, agency and principal. Please do not go online. Agency and principal, yes, that's because a spouse. Okay, I'm expecting more. What of beneficiaries? Beneficiaries of wills, because, okay, so there are some people, for example, in the cases of agency and principal. Remember, the agent is seen, all right? The agent is seen as the principal when the agent is working for the principal. So what this privity of contract may indirectly be implying is that if an agent had been involved in a contract on behalf of their principal, that means the principal cannot benefit from such contract. And so it's going to work a lot of hardship. So we have some specific exceptions. And so let us look at this exception. One of it is agency, like we have mentioned. If you had given authority to a person to work as your agent, remember that agency relationship does not only work in land or estates, all right? I mean, property. It can work in a lot of buying and selling. The meaning of agency is that a person represents you in a transaction or in a contract, and that person will be acting as if it were you. You will give the person the authority. So in this kind of relationship, if you are giving an authority to an agent to work for you or to act on your behalf, it means that the exception here is now saying, although it was the agent that signed the contract on your behalf, you can in the future, even after you have sacked the agent, you can still benefit from the proceeds of that contract. The next one is issue or is trust. What we mean by trust is when it comes to wills. So remember, some of you now would have their grandparents who would have left some properties for them, even when they were not old enough to know anything. And those grandparents are dead now. Now, when it comes to trust, when they are writing the will, or would I say, when they are entrusting a property to a certain people, they will say, please hold on to this property for me. Or for my child, when the child grows up, you would help me give it back to them. Or you would give it to them. Now, remember that the contract was between the trustees and the owner, which is the principal now. It's between the trustee and the person who entrusted those things to them. And so in that case, what privity of contract is actually saying is that no other person can benefit from it. But remember, like we said, don't you think this kind of privity of contract can work actually on the beneficiary? And so that's why we have trustees relationship as being an exception. So the fact that the agreement was signed between the trustees and the owner of the property doesn't mean the beneficiaries cannot enjoy it. That means maybe the children that were supposed to be given the property or whom they were managing the property for cannot enjoy the benefit.
I like all the songs if I'm to sing one, I'll sing Bad Girl that he sang with Ashake.
Bad Girl is sang with Ashake. Okay, so what do you have to tell MTN for this gift?
Thank you so much,
Yeah.
Just tell them to vibe. Tell them to vibe. They're not vibing, that's why they're not coming up. Tell them to vibe.
Queen, please.
Record. She's talking about today. She was event here today. Yeah.
Okay. So the next is in the case of assignment. What I mean by assignment is we call some document deed of assignment. Like you are transferring property to Okay. All right. So when it comes to assignment, that means the sale of landed properties like that. In case it may not anything property. Remember that we have some property that are not tangible. We have intangible property now, like intellectual properties, and we have tangible properties as well. Among the intangible properties are also shares and all of that. What we are seeing here is that where such has been assigned to one person, it has been sold to one person. Under privity of contract is that no other person can enjoy the benefit. I mean, that property cannot be transferred to a person who is not a partaker of the contract. So an exception here is saying that if my father buys a property and it passes on, it doesn't mean I will not benefit. It means that this exception is saying that I can benefit from it and that property becomes mine, especially when it wills the property to me. Okay, so that is an exception. And it doesn't really have to be property like tangible. It can be shares, like I said, it can be intellectual property. Anything property at all, when it comes to it being transferred, it doesn't limit to the two people that were engaged or were involved with it initially. The children or any other person that the owner feels or wishes to transfer it to can also benefit from it. And the next is, like I said, covenant to land too, which is the same thing goes together with assignment. The other exceptions we have is statutory exception. That by virtue of some statute, a third party may take the benefit of a contract. All right. The law of insurance, for example, remember when it comes to the law, we have some law of insurance that's, you know, the fact that two people, a company enters an insurance policy with an insurance company for their vehicle. It could be a third-party insurance thing that if this vehicle is involved in an accident with a third party and it is this vehicle that is at fault, then the insurance company will bypass privity of contract because of due to exceptions, they can give the third party money. It could even be the third party that can sue the insurance company without even involving the person who had been involved or who had entered into the contract with them initially. The next one we have is the banker's commercial credit. You know, this is a device developed to expedite international trade by facilitating prompt payments. Now, in this kind of transaction, there are times that people are, excuse me, please. Okay, so like I was explaining, for bankers, commercial credit. Now, especially in international trades, there are times that before a company outside of the shores of Nigeria comes or wants to be involved in a contract, wants to be involved in a transaction with a company, with a Nigerian company, they are always very skeptical. And when it comes to money, you have to do business. And I think this also should apply to you, that when you are doing business, you have to be very, very careful. So what they would say is that we would want that, because it could be a supply thing, that, oh, we want to production. We want you to produce this for us. Now, the foreign company will be as careful, for example, China, they'll be as careful as anything and say, oh, before we go ahead with this production, we would like that we enter into a credit a credit like our contract should be a commercial credit thing in such a way that you would have dropped some money for us, or you would have given your bank some, maybe inform them that after our production, we will be giving this money, or they may even have raised some checks or whatever that ensures their interest. And so it won't be like after production, then you say, oh, we don't have enough. No. So remember that that contract will be between the bank and the person who have ordered for the items, and not with the China company. But then the credit facility will be done on behalf, or will be for the purpose of the China company. And so privity of contract, the exception here is saying that although the company in China is not privy to this contract, it's not a party in this contract, they can still benefit from it. These are the exceptions when it comes to privity of contract. So like I said, when we started, the general principle is that you are not a part in a contract, you cannot be involved in the contract, or you cannot benefit in the contract, except from some certain exception. We mentioned the case of agency, trust, commercial credits. We mentioned landed property, and so on and so forth. So the next is, now, this is another phase when it comes to the law of contracts. We call this phase the phase of vitiating elements. Now, with all we have mentioned, we have all that we have been doing before now. We are trying to define what contract is. We are trying to tell you what it is not. I have tried to also explain to you the elements of contract. I mean, the things that must be in the contract. I also have explained to you the terms of contract. What are the things? What do we mean by terms of contract? We say they are promises, they are obligations, and all. If we can, and subsequently we talked about privity of contract. In all that we have done, we are just establishing what contract is. All right? But now we are going to be talking about the things that can vitiate a contract, the things that can affect the existence of a contract. Now, it doesn't mean that the contract is not valid. It just means that it can affect the validity of the contract. Now, some of these things can either make the contract void or voidable. It can either make it void or voidable. That means, and amongst it, we have, someone said they don't understand the banker's commercial credit. Now, I must finish my class today. I would explain to you, but I must finish. If I don't finish by 6, nobody's going anywhere. Okay? What I mean by banker commercial credit is that there are sometimes you are involved in a big business, especially in places, for example, manufacturing, production. Now, you have instructed the company to produce these mugs for you, 50 pieces of this mug, and it can cost 1 billion naira. And the agreement is that we cannot pay until we see the mugs. Okay? Now, the company that is producing would also insist that we cannot produce this thing except there is an assurance somewhere that you will give us our money. And so a lot of the time, these people use the bank. And I, who have instructed the manufacturing company to make the mug for me, I would also instruct my company, I would also instruct my bank, and I would tell my bank that this money I have here, you will give it to these manufacturing companies. Oh, God. Sorry. The electricity has been somehow poor. And I think I should stay with my phone, whatever. Sorry, I have to change to inverter. Okay, so like I was, and so for credit now, it would have instructed his bank that, come, I'm going to leave, this money would be transferred to this manufacturing company after they have manufactured, and this thing, you would have entered some terms of contract. There would have been some condition upon which they can transfer the money. So the bank, okay, will be like a trustee for the money, holding the money in trust for the manufacturing company, so that after production, it will be transferred to the manufacturing company. The idea is that the manufacturing company is being wise and very careful so that they can secure the money and there will be no stories at the end of it. This is what they've been doing in commercial transaction. Anyway, this is so that everybody will go after the transaction without any issue. I hope that is working. Anyway, I hope at this point you can get me. So let's quickly go to vitiating elements. So the vitiating elements we have mistake, misrepresentation, illegal contracts, and undue influence or duress. Okay, so let's quickly jump to mistake. What does mistake mean? Now, funny enough, I've always been opening my slide. I would have loved to hear from you for me to know what you understand to be mistake. Now, this is not new to you. The definitions of terms in law is different from the ordinary parlance. If I ask you what mistake is now, you can tell me that mistake is when someone does something unknowingly. You did something, in such a way that you didn't know it wasn't your intention to do it, right? So a lot of times that's what you will term to be mistake. But under the law, mistake is quite different. And the only way we explain mistake is by talking about the types. That is the best way to explain what mistake is. And we have 3 types of mistake. We have common mistake, we have unilateral mistake, and we have mutual mistake. So let me give you an example, just the way it is here. Maybe if I give you this example, it will resolve everything. We normally use example to explain what mistake is, right? So let me give you this example. I have 2 cars. Yes, I have, and I love to use this my example here because it works well for me. You have 2 Peugeot cars. You have Peugeot 507. Is it 505 and 506? Right? You have a Peugeot 505 and a 506. Now, your intention, you wanted, because you just bought the 506, you now want to discard with the 505. Now, somebody else met with you and asked you that, please, I want to buy a car. I want to buy your Peugeot vehicle. And he said, oh, it's available. It costs 500,000 naira. All right? And the guy comes and paid 500,000 naira. And you gave him the Peugeot 505. And he comes back. He says, I wanted Peugeot 506, not 505. Okay? In law, that is what we mean to be mistake. That is what we mean to be mistake in law. Now, let me read what I wrote here. He said, a contract to buy B's car. A thinks he's getting a good bargain. is buying that 505. Is buying it at 500,000 when Peugeot 506 could be like 5 million naira, or not to exaggerate too much, 2 million naira. I'm just saying, anyways, cars are very expensive now. You know, but then he got that, so he was thinking he was getting good bargain for his money. All right. So A later discovered that the facts are not as he had thought. The car is a 1980 model, not so that the car he wanted to sell was a Peugeot 505, not a Peugeot 506. And A has made payment for Peugeot 506 in his mind. So, of course, he would certainly not have paid if he had known that it was a Peugeot 505 they want to sell, because to him, it's an old car. He would have preferred to get the Peugeot 506. So in the general mistake, in the general usage, a mistake is, okay, a mistake, A made a mistake, but in law, there is no mistake in that situation. He wanted a car and he got one. All right. I hope this you can understand my explanation. In this way, it is until, because there was no explanation, he never said, oh, I wanted this type of car or that type of car. So mistake in the legal sense is more limited in meaning than in general usage. All right. So this is an example now. Mistake in the legal sense would arise if, our example, if B had 2 cars, like I've explained, and A intends to contract about the 19, now he wanted the 506, Peugeot 506, whereas it was sold a Peugeot 505. In that case, B's intention to contract about the Peugeot 506, in law, it will have been seen to have been a mistake. And in such a case, a mistake has occurred. And like I explained, we have 3 types. Now, for common mistake and mistake that the both party made, same mistake. Please listen carefully, same mistake. And like I've said, I always want to use example to portray what I'm saying. For example, your grandparents will some money to you, like 50 million naira. And you wanted to buy a landed property. You got a friend who helped you to get a landed property in Ibadan. You had visited the site, you loved the house, it's okay. You and the seller, you are the vendor or whoever wants to sell it, you are in alignment, and then you both live in Lagos State. So you are in Lagos, you agreed to meet at Ojota or at maybe a restaurant, an eatery, in the morning of Monday by 8 a.m. to sign documents. Unknown to the 2 of you, the property which you have come to sign has been burnt down that morning by 7 a.m. in the morning. Now, remember, if that property has been burnt down, there is nothing except that you are buying the land. The building is not on it. And so at that time, they both have made mistake as to the substance, which is the property. Before they sign the contract, the property has been burnt down. Now, they are unaware that the property has been burnt down. And so we call it, they both made the same mistake. And so we call it common. It is a mistake that is common to the 2 of them, or common to the parties. The next one is mutual mistake. That is the case of the car that I explained. I have two Peugeot vehicle, 505 and 506. I wanted to sell 506. You wanted to buy 506. No, I wanted to sell 505. You wanted to buy 506. But there was a mistake we both made mistake, but not common. But we both have mutuality in mistake. There was a mistake, but it was to different things. My own mistake is that I wanted to sell 505. Yours is that you wanted to buy 506. In that scenario, the mistake is mutual. We call it mutual mistake. Parties misunderstood each other in the cases of misunderstanding. The next is unilateral mistake. Unilateral mistake, like the name implies, is a mistake by just one party made. It is just one party to the contract that made that mistake. An example of this mistake is, for example, most of the times normally have criminal intent or illegality in it, like somebody who wants to defraud another. All right, so in the law, it's that one person will know the facts. One person knows that the other is making mistake and he refuses to talk about it. He refuses to say anything about it until that person made that mistake. All right. In that case, we call it unilateral mistake. One person makes mistake and the other was actually aware but refuses or did not inform the person who had made the mistake. So we also have something we call mistake at common law and mistake in equity. And remember, when we started, I started by taking you what common law means and what equity means. So mistake in common law may relate to the subject matter, which is, for example, we mentioned, remember when the example of the common mistake I made was regarding the subject matter, that the land or the house was burnt down. That is mistake as to the subject matter. Okay? Now, wait. Common law takes the view that where a mistake is such that it prevents the formation of a contract, then the purported contract is void ab initio. So look at the example of the property I gave to you. In that case is void. There's nothing to place anything on. There is no land. There's no, unlike the mutual mistake I said they made, there is still, the car is still there. But in the case of the house, so when it comes to subject matter, a lot of the times, like that subject matter, it means that the contract is void ab initio. What it means is that it is void from it has no remedy. There is no remedy. And we also have mistake as to the terms of the contract. And we said terms can be condition or warranty. We also have mistake as to parties to the contract. Now, mistake as to terms of the contract normally come up when it comes to mutual mistake. I want 505, things like that. And when it comes to parties, it's mostly happening in unilateral, where one party tries to disguise as another person so that it can sell their property, so also that the other person can enter into the contract with them. That is mistake as to the parties to the contract. All right. So this kind of mistake is known as operative mistake. Operative mistake can arise in a contract in respect of either. So in these three contracts, where a person disguises to be another, it is void. Where you have issues with the terms of the contract, it is void. There is no remedy. Okay? There is no remedy. We also have mistake in equity, and that would, when it comes to mistake in equity, remember that what equity tries to do is try to ameliorate damages or injury, try to reduce injury, try to reduce whatever pain the other party is going through. So what this is saying is that in mistakes that are not operative, there can be a form of remedy, and that is the remedy that equity tries to bring. And the remedy can be in form of rescission, rectification of specific performance. I know by now you know what rectification means. So for example, I gave the example of PJOT 505 and 506. Okay? It can be ameliorated. It can be redeemed. I mean, parties can decide to sit down again and try to review it. And the person who has sold the car can say, oh, okay, instead of 500,000, pay 250,000. And the other party too can say, okay, I'll pay 250,000. And so by so doing, they will rectify that contract. And so it won't be that the parties will not be able to recover. It will just be that they will rectify it. There could also be a specific performance. The court can order that, oh, if it's something that can be redeemed, pay this amount of money to this person so that you can give them this kind of, let them feel that they've not been cheated and all. Okay, so the next is in the cases of documents that are mistakenly signed. Now, I like to take a long time in this, but then because of our time, I'll still have to talk regarding it. As from now on, you are not permitted to sign a document without reading the documents. Don't say, it's my mommy that wrote it. Your mom can make a mistake. Your dad can make mistakes. Not to talk of people that you are involved in contracts with or in transactions with. Ensure that not only you, that not you really do, the signing of documents or reading of documents is not just you alone. Documents should also be shown to a lawyer who will also help you vet it and inform you that the document is okay before you sign it. Because you never can tell, you may be signing your life-end money. So, under the law, a person who puts his signature to a document is bound by the terms of the document. Like I said, you cannot say, but I did not know. But one thing. You cannot say that. If you not read it, you are bound. All right? You are bound by everything that is in it. However, in contracts, we always have some things, so we have room for exceptions. There could be the cases of defense. The law, however, developed the defense, which may possibly be open to a person who may have signed a document mistakenly. Okay, this is what we call plea of non-expertum. It is not my deed. That maybe I didn't even know what I was signing at that time. I didn't know that this is what was given to me. And a lot of the time, illiterate persons used to come with this defense. They would say, for example, if a person had read something differently to them, they could say, I didn't know this was what they have read to me. And all of that. Okay, so that is it for mistake. Someone said, what if it is under the influence of alcohol? Of course, if you can give evidence regarding that in the court will, of course, grant your defense, except if there's nobody to witness that for you, then you really cannot do it. Someone say, under duress. Remember, we are still going to do it. All right, so the next is misrepresentation. Misrepresentation. So there are times that a lot of the time when we are talking about misrepresentation normally happen maybe at the beginning of a contract when you wanted to start the contract, or at the middle of the contract, where because one person wanted the other to actually be involved or to enter into contract with them, they will misrepresent some facts. Maybe you want to rent an apartment and they are telling you, come, don't worry, there's always light in this environment. I can assure you there's light. I can assure you, if you buy this property, the tenants that are in this property, they are very good. Not knowing that the tenants are owing 2 years, you know. And a lot of the time, the reason why people do this is so that the contract can succeed. All right. So the law tries to protect those that have been induced into entering that contract. All right. So misrepresentation can happen in place of inducement. So misrepresentation may affect the agreement and render it void or voidable. All right. Misrepresentation can either render it void or it can render it voidable. So when we are talking about misrepresentation, we normally talk about some things. Number one, inducement. When we are saying that somebody was misrepresented due to somebody's statement or due to another person's statement, what we mean is that that statement must have induced, you know, maybe you said, this phone, I want to sell this phone. It is, you know, you start saying all these good things about the phone. It can, you know, it's a used phone. Although it's a used phone, but it would work for 30 minutes non-stop without charging. It has this, it has that, not knowing that it doesn't have all of that. You know, if you are telling somebody that I'm selling a used phone for 50,000 naira or for 10,000 naira, and this phone has all this function, it's charged, you don't have to charge it for 30 minutes, for 30 hours, it still works, and give it all these good things, you know, and the person buys it based on what you have said. What you have said in law is seen as inducement. Is seen as inducement. Okay. So under misrepresentation, there's also something we also refer to facts, not in law. So under misrepresentation, you can make misrepresentation as to facts, but not as to law. It doesn't mean that there are times you cannot make misrepresentation as to law. So the one that I mean as to facts is where you are saying that this phone does this phone does that, whereas it doesn't do any of that. You know, that is as to facts. Also, fact, not intention. So a promise or statement of future intention does not constitute misrepresentation. Okay, you are now telling somebody, you know, there's an agreement between you and somebody where that person says, oh, next year I'm going to buy a car for you if you buy my phone now. That is not misrepresentation. Misrepresentation can only be or can only occur as to past or as to present events. When it comes to misrepresentation, the statement must have been addressed to the person misled. So you cannot be eavesdropping. And maybe while you were eavesdropping, someone said, I want to buy my car. The car is, you know, I want to do this. And you went ahead to do that thing. Whereas you were not the one that the information was meant for. You cannot claim for that, all right? You cannot claim for misrepresentation because the misrepresentation was not made to you, it was made to another person. So we used to have this issue with silence. There's this question that we used to ask in law that, does silence amount to misrepresentation? And the answer is yes. Generally, it is no, okay? As a general rule, mere silence is not misrepresentation, which is a general rule, but there are exceptions. Remember that you can, like we said that you can enter into a contract by conduct. You can accept a contract by conduct. And so some people can make statements even by conduct, you know, by their movements, by their actions, whereas they didn't see anything. So let us look at this circumstances in which silence can amount to misrepresentation. One of the circumstances, contract of utmost good faith. Okay, so there are some contracts that are technically called utmost good. We call it umbirimia fidel, contract of utmost good faith, in which there's a duty for a party to disclose. In the case where they don't disclose, then that will be seen as misrepresentation. Okay? For example, in places of shares, if a company wants to sell their shares, in their prospectus, they are expected to say everything, not leaving anything out of it. You cannot say, but the person that bought the share should have gone and they should have done their own due diligence. No. Although in the law of contract, we normally advise that you do due diligence by yourself. But when it comes to shares like that, you are expected to act in good faith as the owner of the company and ensure you tell everybody, intending shareholders, whatever that is happening in the company, the prospects, what is there. You know, before people would have relied on them, whereas some company may be in debt and they may be trying to sell their shares so that they can pay up the shares that they can pay up their debt. And so the debt still accumulates. And so that's why the law says for this kind of contract, you must act in good faith. Also, when it comes to sale of land, a person who is not the owner of a land cannot sell it. You cannot say, but you are expected to go and do diligence and know that I'm not the seller or I'm not the owner. Under the law of contract, you cannot keep quiet in that aspect. You have to tell them, oh, this land doesn't belong to me, it belongs to my dad. And you know, and that is why a lot of the times another person cannot give their property to dispense with their property without them signing the contract or giving authority to another person to sign it. So the next one we have is fiduciary relationship. When there's a relationship existing between parties, you are expected to disclose everything. Example, in cases of guardian and the person who is guiding them and the beneficiary or whoever that they are guiding. Also, in the case of principal and agent, an agent cannot keep anything from their principal because the principal expects the agents to act in fairness. And so you cannot be keeping profits all in the name of saying, oh, but then it's business. No matter what type of business is it, you need to disclose it to your principal. Okay? In the place where it is not disclosed, that will be seen as misrepresentation. Change of circumstances. For example, let's assume that you want to enter into a contract, you want to buy an hospital. All right? Or you want to buy something, you want to buy a phone. Today, when you check the phone was working fine and all of that. And you told Tade that tomorrow I'm going to make payments. But the next day, the phone fell from Tade and it started acting up. But Tade, who was, at that point, Tade need to disclose to you before you make the payment. But because Tade likes money so much, Tade went ahead to sell or to collect the money. And by the time you check the phone, it wasn't functioning well. Under that will be seen as misrepresentation. Because you cannot say, but we negotiated yesterday. But the law is saying that there's a new circumstance. Something else has happened. You need to have disclosed what has happened. Then it will not be left to Tade to either say, don't worry, I'm going to buy it that way or not. The last we have here is full disclosure. A party is obliged to speak. They are expected to make full disclosure. In cases, there should be nothing like half-truths. So let me give you an example of half-truths. It's better you don't even say anything than saying out truths. It's better. So if you are going to say anything, ensure you are saying the full truth. It mustn't be half. It's better you don't say anything. But remember, there are some contracts that you have to say something. You must say everything. All right. Although in some contracts, a person is expected to do due diligence. Although the law of equity will redeem, we try to bring in fairness. But whatever contract you want to be involved with, it is good that you do due diligence. And so in a contract where there is an issue of half-truth, such a contract will not be allowed to exist or will not be respected. Okay? We have different types of mistakes or misrepresentation. What is this? Okay. Let me see. I think there's a mistake somewhere. Okay. Sorry, please. Okay, sorry. All right, I think I can. I hope I can see any, but then I will try. It looks so tiny for me. Let's see, can do 16. Okay, so we have 3 types of mistakes. We have fraudulent mistake, we have innocent mistake, and we have negligent mistake. Just as the way that the name implies, fraudulent mistakes are mistakes that has an element of fraud in them. That is, the person intentionally. Sorry, it's not mistake. I meant misrepresentation. We have fraudulent misrepresentation, innocent misrepresentation, and negligent misrepresentation. So, fraudulent misrepresentation, look, these are the elements. They are misrepresentation that are made knowingly, knowing that the person who made the misrepresentation or who made the statement or who did the action did it in such a way that the other party, they know that the other party is in the wrong, and they will not tell them. Okay, maybe they are lying, they are saying things that would eventually not be helpful to the other party. Also, when they are saying, they are making a statement or they are doing something without truth, and the last one says they did something recklessly, carelessly, whether it is true or false. Okay, so those are what we can see, we can term as fraudulent misrepresentation. The next is innocent misrepresentation. This innocent misrepresentation, it means that there was a misrepresentation, but the person who made the misrepresentation, just like the name implies, did it innocently. They did it innocently. And I'll give an example. For example, I want to sell, I'm into agricultural products. And of course, I have told my Malam Audu from Kano, load this vehicle, load this lorry with 2 bags of yams. And already I have my buyer in Lagos. I have even collected the money from my buyer. Send the money to Malam Audu, who is selling the yam. And I've gotten my profits. Unknowingly for me, when the vehicle got to Akure or Ondo State, the driver noticed that the yams were going bad because of the heat. He quickly sold the yam to people around so that at least everything would not go bad. Unknowing to me, I didn't know that this has happened. Not knowing that my buyer in Lagos State has also collected money from someone, and when the vehicle got to Lagos, the vehicle didn't come with my yams. And so my buyer sued me to court that I have not done my own end of the bargain. Now, in that case, what has happened is called fraudulent, innocent misrepresentation. I never knew that the item has been sold. All right. And so a lot of the times in law, we really don't have, in common law, there is no remedy for innocent mistake. But in equity, there is a remedy of rescission or indemnity. The next is negligent mistake. These are I keep saying mistakes. Sorry, people. I keep saying, and there's nobody to even correct me. Are you sure you are in this class? Anyway, negligent misrepresentation. What negligent misrepresentation means is misrepresentation that was made negligent, just like the name implies. Most especially, someone did it they were reckless, you know, and it always happening, for example, for a professional. If you are a professional, you are expected to act in such capacity. Now, if what you have done is reckless, you were not acting according to what your profession had stated that you do, and somebody, one way or the other, was injured due to your own negligence, that will be seen as negligent misrepresentation. And under the law, there's remedy. Okay? Look at this, we said careless, where somebody makes careless statements, you know, where a lawyer is making statement that eventually is so careless. You know, we are saying that this person, don't worry, you can leave your items with them without advising properly. If it is seen that the person has acted carelessly, it will be seen as negligent misrepresentation. And this misrepresentation can be remedied. We have 3 remedies. We have the remedy of rescission. The remedy of rescission applies to these 3 types. It applies when rescission, what rescission means is that to take the parties to where they were in the first place. So what it means is that, for example, in the place of the yams, rescission means that give me my money back. Give the person their money back. Now, rescission will not give you damages. It will not give you interest. Because if you have given somebody money for 10 days, if you have invested that money, you will have gotten interest. Okay, that's rescission. Rescission is to return every party back to where they were before the contract. And a lot of time is you returning back the money and all of that. The next is damages. You know, in law, we have something called damages. The court can grant damages. Excuse me, please. Yeah. The court can grant damages. And damages are mostly granted in cases of negligent misrepresentation and fraudulent misrepresentation. But it doesn't come up when it comes to innocent misrepresentation, because it is seen, the law tries to protect the person who has made the innocent, because it's more or less like they made the misrepresentation innocently. All right. The next that we have here is indemnity. The case of indemnity, it's mostly come up in the places of innocent misrepresentation. So indemnity is that if at the time when you were trying to contract, there were some things that were supposed to be done aside from the contract itself. For example, when my customer wanted to order from the yams from me, he also paid. He also made payment for where the store that is going to keep the yams. If he has, let's say, for example, that Mrs. Adewumi, when you bring the yams to Lagos, please take this 50 naira or take 50,000 naira for a store for me, at least for 2 days. Indemnity says, in the law of indemnity says that I should return that 2,000 naira, or is it 50,000 naira, that is meant for the store as well. All right. So that is it for that. Please, if you have any question, you can also ask in the chat box, so that I will try to also be answering that. The next one is duress and undue influence. And I think this is very clear. What duress means, in essence, is that it's a common law doctrine. And duress mostly, it means that when at the point of entering into a contract, you were threatened, a person was threatened to be involved in a contract. It was through a threat. For example, if you don't enter this contract, I'm going to kill your wife. Or I'm going to do this, I'm going to do that. You know, those are threats. And a lot of the times, because some people love their loved ones, they will go ahead and do that and quickly sign the contract. Now, recently, we have learned that the law has so much developed. It has evolved in such a way that people don't have to say, I will kill your wife. There are other ways that people can threaten, that people can, they can be a touch of duress in a contract. An example is in the place of economic duress, where one party has an upper hand from another. And so that person who has an upper hand can say, oh, come, if you don't contract with us, this is what we can give you. And if you don't do it, we take our contract somewhere. But because it's a small company, can just give me anything, at least I have something I'm doing. You know, if eventually it was noticed that there was a kind of commercial pressure, there was a form of pressure, it will be seen as duress in law. When it comes to undue influence normally happens in case of where there is a fiduciary relationship. In cases of relationship, for example, relationship of parent-child, doctor-parents, doctor-patients, solicitor and clients, religion advisor and disciple. Now, we normally advise, and in fact, that is the norm, that you are our students. I cannot be involved in a contract where you are going to be a party in it. Because whether we like it or not, if I am supposed to grade you, there's probability that I will have some form of influence on you. And so it can affect how you can be rational in conducting business with me. You may because, oh, Mr. Adewumi, well, let me do it. Oh, if I don't do it, you may fail me, you know. Or, for example, your parents and you want to be, the law is saying that if there's a touch of influence, if it has been seen that your parent has influenced you or have done something that could affect you, which can affect that picture, it will be seen as undue influence. Now, a doctor is expected to advise the client properly, but then let's assume a client wants to sell a woman who has who is sick, want to sell their property. There's probability that they sell that property to their doctor because they see their doctor as a person that they really respect, and also that they just want to ensure that their doctor enjoys the benefits. But then it may be detrimental to the patient. It may be detrimental to the patients. Okay, so what is this? So under duress and undue influence, so I think what I'll do again, maybe I'm going to do a voice notes of all these notes. Don't worry, but I just want to ensure that we finish this today. We've been on contract for like 5 weeks, or is it 4 weeks now? It's getting too long. So let's go to illegal contract. Just like the name implies, contracts that are not according to the law. Contracts that are done that is not according to the law. Okay. So, a contract may be rendered illegal either because it contravenes the rule laid down by statute or it contravenes the rule of common law. It may be against common law, it may be against our laws, our acts or laws of different states. Contracts that may be illegal that are legal by statute, that is, they are formed illegal as formed. That from the scratch, a law prohibits something. The law said that in this country, we are not supposed, I think some of our statute says they cannot, I think our statute says they cannot import rice. I don't know what the position is now. So if anybody brings in rice and is selling it, that will be seen as an illegal contract. because it's against the statutes, it's against the law. Also illegal as performed. Now, there are some contracts that are made illegal by their performance. So let me give you an example where the law provides that if you are going to sell something in Nigeria, now NAFDAC had said something. It is the rule of NAFDAC. If you are going to be selling a product, you must itemize the ingredients that was used in the product. If a manufacturer manufactures or produces an edible product and they omitted something because they think if they write that thing, people will not buy it. And to them, it was that thing that they added that made it unique. Because some people may be allergic to some things. And one of the reasons why they normally state that they should write all this is that some people for allergens. And some products may also be harmful. So in the case where a person had refused to itemize those things, we see that illegal as performed, and so it will be made void. It cannot be corrected. It will be seen as void. Okay? Contracts that are illegal as common law. For example, number one, contracts to commit a crime or to commit a tort, where somebody entered into a contract that, hire killer things. Go and kill this person, I'll give you 20 naira. Or take this 50 million naira, you are supposed to harm this person. But then, they didn't harm the person that they were supposed to harm. Now, the person who had paid the 50 million, can they sue the hire killers to court for not performing their own end of the bargain? It's a question. Okay, so no, they cannot, because it's an illegal contract. In the first place, you cannot even sue. There are a lot, there are a list of them. A contract to defraud the revenue in place of taxation. Those are illegal contracts by statute. A contract that tends to disturb a country's good relationship with a friendly country, all right? So we as a country, you know that this other country, they don't allow, for example, a Nigerian entered into a contract with somebody in a country where they don't allow alcohol, and you were engaged in a contract with a person in that country to export gin, alcohol to that country. Now, that contract in itself in Nigeria is not illegal because we buy and sell alcohol in Nigeria. But selling it to a country who is a friend of Nigeria, but then they don't allow a substance, that would be a contract that can affect the relationship between the two countries, and so that will be seen as an illegal contract. We also have a contract involving trade with an enemy nation. If Nigeria has named a nation, a country, as our enemy, nobody can be involved in a contract with them. If anyone is, it's an illegal contract. The next contract that are prejudicial to the administration of justice. Anything that will affect fairness, that would affect justice, is an illegal contract. A contract that tends to promote corruption in the public, that is also maybe via taking of bribes, those are illegal contracts. So a contract to house the jurisdiction of the court, you enter into a contract and you are saying, come, in this contract that we are entering, nobody can go to court. Anybody that loses. That is not a good contract. That means something can happen in the future, and you are saying the other person should not report where there's a need for them to report. The next is a contract tainted with sexual immorality, that you are saying, if you give me your body, I will sell this house for you. Anyways, those are not allowed in law. A contract, I know some people may have some other things in their mind, but then this is what the law is saying. a contract that is prejudiced to the statutes of marriage, where some people engage in marriage just for maybe contractual benefits. I've learned of some people that they will say they get married in Nigeria because they want to travel abroad. And it's not because they were involved, not because they actually wanted to in a relationship. Those are like contract. Maybe they enter into a contract to do that. That is an illegal contract. What then is the effect? What happens when there's an illegal contract? Where the contract is illegal, such contract is void ab initio. No remedy. Nothing to remedy it. It is void, totally void ab initio.
Maximum value. Yeah.
Okay, so the next that we have is contract in restraint of trade. Contract in restraint of trade. Now, when we are talking about this see, there are some times that I'll give an example of some companies, especially maybe like MTN, all these companies that had to do with apps and all of that. They would have told their employee that when you come into our organization, if you must leave our organization, you cannot work in this kind of organization in another 3 years after you have left, or after you are not in our organization again. Okay? So those are contract. In law, it is against the law. Nobody can restrain another person. But remember that everything in law, when there's a principle, there's always an exception.
Hello?
Yeah, okay, so the basic thing here is that don't worry, we are going soon. I know you are ready to leave. Ekpele. All right, so let's just try to conclude and we can go from here.
We can go from here.
All right. So the contract in constraint of trade that I said that it is not acceptable in law, but there are some exceptions.
Acceptable in law.
And the exception is that okay. So the exception is that, you know, there are some cases, let's be real. There are some people, they have fraudulent intent. There are some employees that are very, very fraudulent. They do not have any good intention. So what the law provides is that there are some cases that can be allowed. For example, where it is reasonable as between the parties, restraint should be reasonable in cases where it seeks to protect some property or other legitimate interests, number one. Two, it can also be acceptable where it is reasonable as regards the interest of the community, that it is not injurious to the public. For example, a restraint which deprived the public of skilled services of a convener was held to be invalid, you know. Now, you said that you have trained this person to convey, to have some skills, but then the agreement was that if he leaves your place, he cannot have his own practice where it's going to be tutoring people. So in this kind of case, it was agreed that it was decided by the court that will not be acceptable. Okay, the types of restraint that we have restraints in contract of employment. There are some that's excuse me, please. Okay, so I'm going to So I want you to look at this link now. Quickly go on this link and answer the questions immediately. You have 8 minutes to answer the questions. I have also shared it on your Zoom, on the YouTube. It's on the YouTube. Quickly go ahead and answer the question. That is your first test. You all have been informed last week of this test. So quickly.
Sorry, ma, we can't see this. We can't see the form, ma. That's it.
There's no link, ma.
Go ahead and answer the question within 8 minutes.
There's no link on Zoom.
Ma, please send the link again.
God, I cannot hear you this time. That is fine.
There is no link, man. There is no link.
Man, there's no link. There's no link.
Those on YouTube have seen it, oh. I've sent it, oh. So please, let's quickly.
Man, there's no link on the Zoom. Man, resend the link.
You better stop saying there's no link when some people have comments already. Class red. And remember, those that are not in my class, if I see anybody that is not in this class and answer the question, it will not be graded. If graded, I will not impute it for them. Presently, I have how many here? I have just 163 on YouTube. And I have 298 here. So if you are not here, I'm going to close YouTube and I'm going to close entrance into this place as well. We have 3 minutes to go. You have 3 minutes to go. Okay, now.
And look, is your phone fast? And look at, is your phone fast? I should send link to you. Show me to please. Like, someone putting in field form. You just copy the question. By your this thing should load. Just copy. God, what is this thing now again now? Okay. Oh, no, it's in this. It's not even. Fuck. No, this one is not fun. This thing is not even. Yes, Jerry.
Your mic is on, David. Your mic is on, David.
I just nice mix some David.
You have just 1 minute to go. 1 minute to go. Get ready to stop. Thank you. Thank you. Do have a wonderful weekend. Bye.
Thank you very much.
Ma, please.
Thank